You mentioned and you hit upon this idea of limited defense resources. That's a problem in all of law. That's certainly a problem in criminal law. That's certainly a problem post conviction. Was that, or is that rather, an issue that you see in the cases that you now litigate as a lawyer?
I mean, absolutely. We see this time and time again. I teach an undergraduate class at Georgetown University called Making an Exoneree with my childhood friend Mark Howard. I can't tell you how often our students know more about the case in 2 weeks than the original lawyers did. And the problem we always face is trying to get competent post conviction counsel. And that's because some of these cases are 10, 15, 20 years old. The records are thousands of pages long, and it's extremely costly, especially for solo practitioners to take these cases on. I think the ABA did a study years ago, and they said if somebody's been incarcerated, I think 15 years, post-conviction lawyers could spend anywhere between $3 and $5 million trying to reinvestigate and litigate these cases. And I consistently tell people that if you think on an average year, we probably have 100 to 180 exonerations, which is a number that should scare everybody. Imagine if the billionaires of this world donated 0.5% of their net worth to defense organizations to increase the number of people doing post conviction work. How many more exonerations would we obtain?
And in your experience, do these wrongful convictions come about because of prosecutorial misconduct? Is it police misconduct? Is it a combination? Is it something else entirely?
It's everything. It's prosecutorial misconduct, police misconduct, false confessions, junk science, bad collection or preservation of evidence, jailhouse snitches, and sometimes it's also bad lawyers. People I think have to really understand that, especially in murder and serious sex crimes, they're challenging cases, they're difficult cases. And if you're not prepared to really do the work, you shouldn't do the work. I think they've said that in most of these cases, if you go back and the lawyers were interviewed, many of them said they weren't prepared for it. But the other thing is that even the lawyers that were prepared for it were up against the largest and most powerful law firm, no matter where they were in this country.
The government.
And the government. And I can't tell you how often I ask groups of students, which is the most powerful law firm in your county? And I could tell in the last 3 years, there was only one person that ever got it right. And that was an incarcerated student in District of Columbia that I recently spoke to, the prosecutor's office. I said, how is it that only one person in 3 years knew it right away? I always get, I don't know. I go, yes, you do. It's the government. Subpoena power, arrest power, wiretap power, kidnap power. They hold the evidence, they suppress the evidence, they hide the evidence, they lie, they cheat, they steal, and it's just wrong. It's just wrong because if you go to the National Registry of Exonerations, which I think every one of your students should go to, if you look since 1989, how many innocent men and women have lost, I don't know, it's like 25,000 years being wrongfully imprisoned.
How much of this, to some degree, falls on law schools to limit the academic portion of their curriculum and perhaps cut off the last year and a half? I understand there's a business model in place. I get all that. Cut off the second year and a half and perhaps turn it into an apprenticeship program where they can work with criminal defense lawyers, organizations, and get kind of going, rather than taking useful, interesting classes in the last year and a half, but perhaps classes that will prepare them not as well.
So it's very interesting. One of the former deans of Touro Law School said, so many law schools in America graduate good students. He said, we don't graduate good lawyers. And he said, the model of law schools needs to change. And one of the ideas is the last year is more of a practical approach. I think any student who is looking to go into become a prosecutor or a defense lawyer should take a wrongful conviction class, should go to the Innocence Project to really understand the power that they had. When I taught a wrongful conviction class, half of my students were prosecutors, wanted to become prosecutors. And I reminded every one of those that want to be prosecutors that the power that they held. And I said, realize this and always remember this. If you have a cop or a witness who testifies in one of your cases and you know is lying, you don't trust them. If you have them in another case, don't trust them either. And do the right thing, dismiss the case. And I found that afterwards, one of my students came to me and said, I did what you said. I dismissed both cases because I realized the power we had as prosecutors, and I prevented somebody from possibly being wrongfully convicted and incarcerated. And they reported that officer to the supervisory people. And it's interesting because I said, think about what you did. You upheld your actual duty, which is a duty to seek justice, not merely convictions.